Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing our video series designed to educate the public, so please subscribe to our channel. When we talk about shared custody, the question is often raised, can I get shared custody even though I live in Michigan and my ex lives in New York? Is that possible? Well, the answer is that you can get joint custody even in a situation where you don't live together. Courts like the term of custody to reflect the reality. So surely if there's a joint custody arrangement and then someone picks up and moves and never see their kids, they're probably not appropriately entitled to the benefits of the joint custody format, the lower support, etc. Having said that, if two parties agree, look, we're going to do joint custody, but here's how we're going to do it. You're going to leave, I'm going to stay, and I'll have the child during certain times during the academic year, and you'll have the child in all the breaks and all the summers and all this and all that. Remember, joint custody doesn't necessarily mean that it's 182 and a half overnights for each parent for the 365 night year. That's not exactly what it means. There can be some flexibility there. Sometimes mom may get more days during that year. Next year, maybe dad will get more days. It's a legitimate way to handle your shared custody. It's not a disqualifying factor that the parties live in different states. It's not disqualifying to the notion of a shared custodial arrangement. It does, though, raise some practical considerations. So when you have that situation, for example, there may be travel expense associated with who's paying for bringing the child here, bringing the child back, and all this stuff. That could be one aspect of it. There could be other things that come up. It requires a lot of cooperation. It requires a lot of good faith on the part of both the parents in order to work out a truly joint situation where somebody's out of state. And you have to ask yourself, am I likely to realistically have that kind of relationship with my ex? If so, fine, but there are some relationships that we just know are not workable to that level because the parties just don't get along well enough to handle that kind of relationship and that kind of parenting time, etc. So you got to be realistic. Having said that, if you sit down and you can work it out, it's an agreement where even if you get more days one year, you'll make it up to the other one the next. The court will likely go along with that arrangement, and as long as the two parents can work it out in a peaceful, logical way, the court will usually let them do it. Remember one thing, the judge doesn't want to parent your kids. The judge doesn't want to get involved in whether or not you're happy with your parenting time or not. It's the worst thing the court wants to do is get involved in that. The court would rather have you work it out like adults, just like you were married and you work things out without the judge. However, the court is there for you if you can. Now, if you have any questions about your case, reach out and we'll be glad to help you out.